Hello students, for drafting, pleading and conveyancing. Today's topic is notice to the tenant under section 106 of Transfer of Property Act 1882. So first let's see what section 106 states. So section 106 of TOP states this, that duration of certain leases in absence of written contract or local usage. So in the absence of a contract or local law or usage to the contrary. So if there is no contract, there is absence of a contract, or there is absence of a local law for a immovable property for agricultural or manufacturing purpose. So if an immovable property is used for agricultural or manufacturing purpose, and the lease uh, and that property is on lease, and there is an absence of contract, then it is deemed to be a lease from year to year. So then it means that it is a year to year lease, and it is terminable on part of either of the lessor or lessee. So both lessor and lessee can terminate it. The time period for such kind of a lease is year to year, and uh, there is a requirement of 6 months notice. And a lease of immovable property for any other purpose. So there are two kind of lease it is talking about. The first one was for the agricultural or manufacturing purposes. Now here it is talking about a lease for any other purpose for immovable property. Then in that kind of case, the lease will be from month to month, and it can be terminable on part of either lessor or lessee, and the notice period in such kind of lease is 15 days. Now, subsection 2 of section 106. Notwithstanding anything contained in any other law for the time being in force, the period mentioned in subsection 1 shall commence from the date of receipt of notice. So, that the period mentioned in subsection 1 will commence from the date the notice is received. There is the date of receipt. So if the date of receipt says that the notice is received on 7th May, so from 7th May the time period will uh, start. From that time the time will begin in force. Now, subsection 3. A notice under subsection 1 shall not be deemed to be invalid merely because the period mentioned therein falls short of the period specified under that subsection. So, just because of falling short of the period specified under that subsection will not make the notice invalid, and where a suit of proceeding is filed then after the expiry of the period mentioned. So if in case a suit or proceeding is filed, and the notice is sent after the expiry of the period mentioned in that subsection, then in that case the notice will not get invalid. Subsection 4. So so now instructions that are there for writing an eviction notice. So this notice is given for the eviction always. So the instructions that are important for writing this kind of notice is that mention serious, valid and legitimate reason for issuing such a notice. So there should be a serious, valid and legitimate reason for issuing such kind of a notice. Second, the other important legal requirement is this, that to guide the tenant on fixing the amending action. So you need to guide the tenant that how can the amending action be fixed. The third important instruction is an eviction notice should mention the certain period of grace time or period before the actual eviction. So it should give a grace time, and that grace time should be mentioned. Another instruction that is important is that an eviction notice has to have a warning tone, and it should not be threatening. Then to make sure that copy of the lease agreement is there with the notice. And eviction notices should not be very long. They should not have unnecessary details like characterizing of the tenant, because that is not that is an invalid point altogether. So it should be not very long. Now common grounds for eviction notice is that demand for Possession. So, when a tenant has been previously given a notice of lease violation or the notice to quit because there is a non-payment of rent or where the landlord has not yet terminated the lease. So, in this kind of case, one can demand for possession if there is a violation in the lease, if there is non-payment of land, or if the landlord has not yet terminated the lease. So, in this kind of cases, there can be demand for possession. Now, notice of lease violation. When a tenant has failed to comply with the landlord rules or breached a term, the property owner can choose to terminate the contract or the agreement or the lease if the violation is not remedy. So even whatever the violation is, if it is not remedied, if it is not removed, then and if the remedy the violation itself at the tenant's expense, then in these two cases, the notice to lease violation can be given. Now the notice of termination. When the landlord wishes to terminate a periodic tenancy such as month-to-month lease or lease requires advance notice to terminate the lease. That's all. Thank you so much.